The approach to insolvency all over the world has changed. Previously, if you were an individual and you were bankrupt, or if you were a company and you became insolvent, society frowned upon you. It was bad. The law was harsh. People went to jail.
The basic idea was that if you were a financial failure, then you were ostracized, and everything was done to ensure that whatever debts you owed were recovered, probably in the most harsh way possible, and also without preserving any value.
Financial crisis, sometimes called insolvency, generally refers to a situation when a debtor cannot meet his or her financial obligations as and when they are due. When a situation like this arises, the debtor can either opt to revive the business through administration proceedings for companies, an arrangement for individuals to go out of business through liquidation of his assets. An effective insolvency legal regime, therefore, plays an integral part in liberating productive resources from an unproductive enterprise. This would ensure that creditors and potential investors in other enterprises are protected in the event of business failure. Now the law has changed. The approach is that it is normal for business to experience financial difficulty. Sometimes businesses suffer because of hard economic times. In the year 2011, Uganda passed the Insolvency Act. So what does the new law bring to the table?
The law now creates avenues for business rescue. The law provides for administration.
This law has proven important as it serves as a safety net for business activity, ensuring that when businesses face financial difficulties, mechanisms are available to either rescue them or maximize the value realized from their assets through their deployment to more productive firms. The idea is to assist the business to exist. A sound insolvency regime is an incentive and has a direct impact on economic performance.
Insolvency is there to say, is it a problem of how it is managed? Did it use inappropriate financing? Can we give it a lease of life? Do we need to inject more capital in it? So we should not, the idea is that we should not always kill a business that is experiencing difficulty.
Insolvency is so critical to Uganda in as far as being competitive in attracting investment is concerned. An investor looking to invest in the country will be interested in the insolvency law.
For me, what excites me is the way insolvency is contributing the competitiveness of Uganda as a country. Before you enter a jurisdiction, you must look at how do I enter business entry, but you also must look at business exit. So it's exciting that we as Uganda have a law that is clear and is competitive enough to attract investors, to make Uganda competitive as a country.
Uganda, like many other countries around the world, are competing for business. Indeed, if you look at the World Bank, they have a report called Doing Business Report, which they issue on an annual basis. And it has both of them. How do you set up a business, and how do you handle its insolvency? Both of these are used to rank countries. Now, if we just concentrate on how easy it is to set up a business without taking care of insolvency, then Uganda's ranking in the world will not be as good as it should be.
What advantages does the law bring to the table?
The 2011 Act does two things. It ensures orderly collection of debt on the one hand, and where possible, preservation of value.
So the beauty about business rescue is that you give that company a new lease of life. The investment company, the tax authorities continue to benefit from it. The stakeholders continue to benefit from it. There may be the present shareholders, there may be new shareholders who are putting money, whatever it is that the investment continues. You have a continued corporate citizen that is not dead, continues to live. In liquidation, you're putting a company in a coffin and burying it.
For example, very few people actually appreciate that most of the airlines in America are under what they call Chapter 11 bankruptcy. They fly, but they are in bankruptcy protection. Why? That the airline may be facing problems, but do you want to stop it from flying?
When Uganda Airlines was declared insolvent, it was totally broken up. There was no attempt to preserve value through, for example, a process of restructuring, because it just felt people had to be paid and there was nothing to preserve. Now today, we want to revive Uganda Airlines. And that's going to cost us a lot more money than if we had, for example, decided to balance debt recovery with preservation of value. It is much easier to keep the airline flying than to shut it down and then get it to fly again.
What happens where administration and reorganization fail?
Just like you take your patient to a hospital, you hope that the patient will recover. Sometimes it doesn't work that way, the patient might die. We have situations where companies actually have to be wound up.
Even where the business has to be wound up, the law now provides for preservation of value to avoid asset stripping.
What we have is a law that provides for orderly winding up proceedings.
Is the law pro-creditor or pro-debtor?
It does seem to strike a balance. A debtor can still be able to, get protection, but within specific time frames to allow him to negotiate with creditors. So the creditors have a say, and that's where the balance is.
Uganda Telecom is one of the major telecom players in the country. UTL was on the verge of being wound up largely because of maladministration. A decision was taken to place it under the official receiver for administration. UTL is the first company to be tested for management under the new insolvency legal regime. UTL's case provides critical lessons on what the law brings to the table.
Right now where I'm seated is Uganda Telecom, and the only reason why I'm here is that Uganda Telecom is under administration and official receiver was appointed as administrator of Uganda Telecom. It commenced on 28th April 2017. It's now approximately, I think, 6 months, approximately 6 months. Within those 6 months, we can talk about significant achievements. Significant. By the time we started administration, for example, network availability was at 75%, meaning the chances of calling someone on UTL and the number going through were extremely limited. So network availability was 75%. As we speak now, network availability is 93%. Uganda Telecom is now dictating the price of internet in the market.
Today, UTL is not only vibrant but also is paying taxes. UTL is employing people. UTL is contributing to the influence, the trajectory of ICT in this country.
If the path of liquidation had been taken, today UTL would be no more. The law now creates a body of professionals called insolvency practitioners. Under the Insolvency Practitioners Regulations, all practitioners are required to register with the official receiver and get practicing certificates.
These practitioners at the same time are required to file with us annual returns of the cases they handle during the year, and we renew their certificates. So in the event that there are reasons on which we can base ourselves not to renew their practice, then we don't give them certificates.
I call upon all lawyers, accountants, the chartered secretaries to take interest in the field and take up advantage of the opportunities that are available, so that to grow the economy and insolvency into a modern system.
The legal regime now also provides for cross-border insolvency. The provisions require the Chief Justice to enact regulations to implement this part of the Act. So the Rules Committee of the Chief Justice, together with the Uganda Registration Services Bureau, have worked together on the regulations. These guide the process of cross-border insolvency. Cross-border insolvency means that the entity has assets in more than one jurisdiction. The business may also be in foreign jurisdiction, but with assets in Uganda.
Uganda is among the 21 African countries that have frameworks for cross-border insolvency. A key factor in cross-border insolvency is one, the legal frameworks that support that, but also technology. So when you have petitions filed in multiple jurisdictions, you cannot resolve that without getting the courts to talk to each other.
At the international level, Uganda is visible in insolvency practice.
We are one of the few African countries that participate in the deliberations of the International Association of Insolvency Regulators, to which we are members. We as a country were one of the few countries that started the Africa Roundtable that is focusing on those unique areas where insolvency affects us as Africans. We participate in the Ancestral Working Group 5 on insolvency at the United Nations. And our contribution has been noted not only locally, but also regionally and internationally. So I'm proud that we as an office are participating and making a meaningful contribution in the growth of insolvency.
The official receiver or Registrar General is the regulator of insolvency practice, having been appointed by the Minister for Justice and Constitutional Affairs. He assists businesses in improving their credit environments. He does this through the development of more effective insolvency systems. This is achieved through international standard setting and technical assistance for implementation. The office helps to save viable businesses while allowing failed businesses to exit the market efficiently and effectively. So how would Ugandans prepare for situations where they are faced with administration, reorganization, winding up, or liquidation?
To understand that those things will happen, there will be struggles financially, there will be business failures, but the most important thing is how can you learn out of this process? How can you get out of it using the legal regime that is in place now?
Any challenges with the process of administration as opposed to winding up?
What we still need to do is, first of all, to have a very large body of credible insolvency practitioners to ensure that everybody is equitably paid. I think we'll see greater activity in the area of insolvency.
There is a need for training of practitioners, starting with students in law schools.
In teaching, I focus on the fact that the best way to prepare for insolvency is to govern your company properly and to address those questions even in raising capital. Rather than thinking of insolvency as the end of the process, think about it even at the beginning. And it's given us some good results.
I think all stakeholders need to get trained in really the modern ideas around insolvency, right from basics. The lawyers, the judicial officers, even the public.
The efforts now are to strengthen and build the legal and institutional capacity of the official receiver to ensure that the duties are executed in accordance with the law.
In terms of IT, digitizing our information in the bureau, in the process of making our records digitized. We're also working on the insolvency practitioners register. Certainly we should have a clean register for all insolvency practitioners. If anybody is interested in appointing anybody as an insolvency practitioner, should just look at that register.
And once we have a professional board of practitioners, we have a regulator who is focused on ensuring that insolvency works, and the courts of law working together, then I'm confident that we shall have one of the most vibrant insolvency practices in the world.
The courts will need to be empowered to ensure that justice is dispensed in this specialized area.
In insolvency, we talk about efficiency. You don't want to file a petition and it is in court waiting 2-3 years to be resolved. Time, like they say, is money. case backlog is bad for cross-border insolvency.